Hello everyone, and welcome to today's webinar, in which we'll be covering the GDPR priorities for local government and looking at the approach organisations should take in establishing their compliance programme. This is the third in a series of 3 webinars that we've done. The previous 2 are available for download from IT Governance website and from Agilisys. My name is Simon Merrick, and I lead our GDPR and cybersecurity advisory practice at Agilisys, and I'm excited to introduce my co-host, Alan Calder, CEO of our partner IT Governance. Hi, Alan.
Hi, Simon, and good afternoon, ladies and gentlemen. My background in data protection and cybersecurity goes back some 10 or 15 years to the company which I led was the first organization in the world certified to what is now ISO 27001, and we as an organization have been involved in data protection for years and years, and particularly in GDPR since it came into force in May 2016. We've become effectively the market leader in terms of GDPR products, training and services, but we supply a much broader range of products and services that help organizations tackle in a joined up way the complete set of issues from cybersecurity all the way through to IT service management under the general heading of IT governance, risk management and compliance.
Thanks, and along with myself, I'm also pleased to welcome and introduce Robert Florendine. It's the solution manager working with us in Agilisys. Robert is going to be talking later about some of the challenges that organisations are going to face in completing their data audits. So we look forward to hearing about that. Agilisys has been presenting these webinars with IT governance principally because we're a transformation specialist, and GDPR, we believe, is a transformation opportunity. We run IT, business support, customer services and transformation services for a number of local authorities and private sector clients. So we operate as a data controller and a data processor as well in the sense of GDPR. So in our sense, our take on GDPR, it's an opportunity to make engagement with service users easier. It seeks to make that engagement more secure and transparent, and it's also just about doing the right thing. So just before we quickly run through the agenda, just let you know the webinar is being recorded. It will be available for download and sharing with your colleagues and networks. Attendees are going to be muted during the session. If you do have questions during the webinar, please do go ahead and use the questions function on this webinar. And we will, at the end of the session, Alan, Robert and myself will try to answer those questions. We've also added some self-help information in the slides on this webinar if you think your organisation needs help complying with GDPR, and of course we'll be pleased to assist if you want to talk directly. Alan is going to talk through an overview of the GDPR, and then we'll dive into the pressing challenge of dealing with breaches for local authorities. Then we're going to be looking at the major components of a compliance programme, namely the data audit and mapping activities. We'll be dealing with subject access requests, and then finally we're going to look at different ways in which the data protection officer role can be resourced and facilitated. And Robert's going to walk us through some of the more technical challenges that you'll need to consider and overcome when you design and establish your data audit and handle those subject access requests, especially in the age of cloud services and the proliferation of different storage options for personal data. So Alan, over to you.
Grand. So we're going to be having a quick look at the impacts of GDPR on local government. Running right the way through the regulation is a very clear recognition that local government, public authorities all have a slightly different set of obligations and a slightly more complex set of requirements in terms of how they comply with data protection regulation than do what you might call more straightforward, although not in reality, so commercial organizations. First of all, timeline. GDPR was passed and entered into force in May 2016. It applies from the 25th of May 2018, so we're well over halfway through the transition period. By the 25th of May 2018, any organization inside the European Union or which is providing services to residents of the European Union needs to be in compliance with GDPR. So that's not complying with effect from, it's in compliance by, and every bit of processing that you're doing, all the data that you're holding needs to be held in compliance with GDPR by the 25th of May. And compliance with the GDPR essentially means acting to protect the rights of data subjects, which are that their data will be processed securely, that the processing itself will be secure, and that organizations will adopt appropriate technical and organizational measures to do that. You can download a copy of the regulation. It's available in all of the national languages of the European Union from the link which you see at the bottom of this web page. Impact of GDPR is, of course, what you might expect from something which, according to the government and expressed in the most recent Queen's speech, that the UK should have a world-class data protection environment. It should certainly be a country that embraces exactly the best that's going on across the world, and the best that's going on across the world is the EU General Data Protection Regulation, in which, of course, the UK's Information Commissioner had a significant role to play while it was being developed. So GDPR comes into force in spite of the fact that Brexit is in the country's strategic lifeline. It will apply both before and after the regulatory process. The transformation of European Union law into UK law is designed to ensure that regulations such as GDPR, having come into force prior to Brexit, remain in force after it. So there is no possibility that GDPR will not apply on account of Brexit. And anybody who thinks that should disabuse themselves of that notion as quickly as possible. The scope of GDPR in terms of what's called material scope is it protects personal data. That's the data of natural living persons, not legal entities, not deceased persons, but natural living persons, and says that the data is protected, the processing is protected, and they're entitled to free movement of their data within the European Union. And any data that is collected by automated means or intended to be held in a filing system, whether automated or not, is going to be within scope for GDPR. So that's pretty well any data. A pile of calling cards which lies jumbled in the corner of your office is clearly unstructured, not part of a filing system. You could probably claim that they're not subject to GDPR, but pretty well everything else is. And if you're a controller or a processor inside the European Union or a controller or processor outside the European Union providing services into it, you are within the territorial scope of GDPR. And before one thinks about what GDPR says, it's worthwhile being aware of what happens if you don't do what it says, because that can lead one to have a better focus on what you need to do. And the starting point therefore is Article 79, which is that any data subject has the right to an effective remedy against a controller or processor who's not processing their data in line with GDPR. So they can have bring a legal action, have a finding against you that requires you to change what you're doing. They also have a right to compensation, and that particularly applies if they're able to demonstrate that they've suffered material or non-material damage. Non-material damage, you'll remember, will include people who feel that they've been desperately upset by the fact they've discovered that you've been processing their data without their knowledge for a number of years, and there is no ceiling set to the size of the compensation which is possible. And we believe it's highly likely that there will be advisors who are prepared to help individuals pursue those kinds of rights. And then, of course, there are administrative fines. So not only can you as a public authority suffer a fine because there is an individual brings an action, there's also the possibility of administrative fines where there is a breach. the Information Commissioner can levy a fine up to 20 million euros for significant breaches or 10 million euros for lower level breaches. There is an extent to which member states may determine how those fines are applied to public authorities. We don't yet know how that might act in the United Kingdom. It's one of many areas on which the government still has to produce the outcome of its consultation process. From a planning point of view, the logical thing for any public authority is to assume that to one extent or another, you're going to have to be able to demonstrate compliance and to get on with doing so. The window for compliance is closing every day. It's between now and May the 25th, 2018. So how do you get to have a fine? And the way you get to have a fine is, of course, first of all, that a data subject brings an action. So if a data subject brings an action, they seek a judicial remedy, they bring an action against you for financial compensation, that puts the issue onto the Information Commissioner's radar, and there's therefore a likelihood that there'll be an investigation which could lead to a fine. More likely, though, is the outcome of you having to report a data breach. And while it's been an administrative edict in the United Kingdom for some years that public authorities have to report data breaches to the Information Commissioner, this becomes a legal obligation with effect from May next year. And the legal obligation applies in two ways. The first is that it applies to processes. We'll look a little bit at what a processor and a controller is shortly, but processes, if they suffer a data breach, by law have to inform the data controller as soon as they become aware of it. And there are no exemptions to which breaches they have to tell a data controller about. So size or seriousness is not a basis for deciding not to inform a controller. Data processor has to tell the controller. Data controllers have a maximum of 72 hours from when they first become aware of a breach to report it to the Information Commissioner. And if you can't report it within the 72 hours, you've got to explain why not. When you report it, you've got to explain what happened, what you're doing about it, the steps you're taking. And while there is a built-in opportunity to provide that data in tranches to the Information Commissioner, the fact that you have to provide it in tranches because you're ill-prepared to do so will not be taken as anything other than evidence of negligence. So breach reporting is mandatory. 72 hours runs from when you first are aware of the breach. And if you bear in mind that many breaches occur sometime on a Friday, because hackers know perfectly well that IT organizations, IT teams go off sometime on Friday afternoons, and that'll give them the whole of the weekend to wreak mayhem on whatever they've managed to get access to. You've got to report the data breach to the Information Commissioner on Monday morning. So having properly prepared incident response and data breach reporting mechanisms is an important part of preparing for GDPR. It's kind of useful to look at some of the information about cybersecurity breaches. The Ipsos Mori survey carried out this year says that a very significant percentage of breaches are driven by people responding to fraudulent emails or going onto fraudulent websites and doing things they shouldn't do. So this is about social engineering, inadequate staff knowledge and capability. The second highest is from viruses, spyware, and malware. The WannaCry attack is a very recent version of a high-profile and wide-reaching attack which impacted many organizations in the public sector. Social engineering, spoofing, ransomware, unauthorized use of computers, all of those are very significant types of attack that cause disruption to business. And all of those are, in terms of GDPR, data breaches if they affect personal data, and almost always they do. So the reality for most organizations is that the breaches are likely, and they're likely to come from issues that you could do something about. Remember that for an attacker, they only have to succeed once. They only have to succeed once in getting somebody to click on a fraudulent email link, whereas you have to succeed across all of your staff against all of the fraudulent emails, making sure that nobody is going to click on one of those links. There are circumstances under which the data controller has to tell data subjects that there's been a breach, and that's specifically where the breach is going to, or is likely to, trigger a high risk to the rights and freedoms of data subjects of natural persons. High risk is not defined in GDPR, so that means that you need to have carried out a risk assessment. We'll touch on DPIAs shortly, and a risk assessment should be looking at the impact on data subjects of a breach, and you should have an open and transparent basis for determining what high impact looks like, and certainly if there is going to be a high impact, then you need to have a process for informing the data subjects without undue delay. Without undue delay is still not defined, but without undue delay, you need to tell data subjects so that they can deal with it. We imagine without undue delay being a matter of hours rather than a matter of weeks. Your decision about what to do can be overridden by the information commissioner, whose obligation is to ensure that you as a data controller are doing everything you can to protect the rights and freedoms of data subjects. You don't have to report a breach if, although there is a high risk, it's unlikely to materialize. You don't have to report a breach if you've taken appropriate measures to contain and, you don't report it to data subjects, taken appropriate measures to contain it, or if it would involve disproportionate effort. And if it involves disproportionate effort, GDPR says that's fine. You can, rather than telling them all individually, you can take out a newspaper advertisement or tell them about the breach through social media. So without undue delay, not later than 72 hours, failure to report must be explained. You have to describe what happened, what types of data have been affected, how many records and data subjects have been affected, what the consequences are likely to be for the data subjects, what measures you have already taken and will be taking to mitigate the breach, who your data protection officer is, and in the process of putting together your response, you need to be keeping a record of everything that you've done to enable the Information Commissioner at a later date to assess the extent to which you've complied with your obligations to report properly. So incident response and data breach reporting becomes a very significant area of activity under GDPR. And given that the practical reality is that all organizations are going to be breached, then you need to have already worked out how to escalate an incident, how to turn it into something which is capable of being assessed as to whether it's going to trigger a high risk or not, whether it's reported, how to report it. All of that needs to be pre-planned, rehearsed, and effective. You also need to be thinking about how you can prevent data breaches, because if the easiest way to get into trouble with the Information Commissioner is to have to report a data breach, following which there'll be an investigation, all your misdemeanors will be uncovered, and then the likelihood of some sort of fine. Obviously, the sensible thing to do is also to work out how to prevent data breaches, and that starts with improving governance. So looking at the board, the top management, council, executive, looking all the way through the top of the organization and making sure that there's proper accountability, a proper understanding of the organization's exposure, appointment of a chief cybersecurity officer, really important part of making sure that cybersecurity is practically dealt with. We'll talk a bit about a DPO shortly, because DPOs are equally important. But from a security point of view, a CISO who owns cybersecurity. Make sure you've got an effective method for monitoring cybersecurity readiness. You've got proper oversight of data protection. You've got an internal cyber incident response team, preferably with a senior cyber incident response officer who can determine how to respond effectively when there is a breach. Rehearse your breach reporting, make sure that you take and put in place appropriate assurance and certification frameworks like ISO 27001 as a mechanism for ensuring that cybersecurity is tackled intelligently and systematically across the whole of the organization. Make sure you get good at identifying and reporting incidents, reporting data breaches internally. That enables you to deal with issues before they escalate. When you look at the history of most of the major breaches that have taken place over the last few years, from TalkTalk through to Sony, what you see is a pattern of repeated small breaches, each of which is demonstrating that there are weaknesses in the defenses, none of which lead to remedial action from the organization. And then finally, of course, the attackers, knowing that they have a number of ways in, will make a major attack on the organization, which will quite often lead to the organization being in very significant trouble. So dealing with breaches is a key part of your underlying security practices. Get on top of patching. Make sure that patching is up to date on systems and on servers. It's not unusual when we do penetration tests on clients to discover that even though they think they're up to date, there are going to be a number of servers or systems which are unpatched or would still have default configurations. Change default configurations. Go for the standard secure lockdown version on servers and on all devices. Test your perimeter, test internal security, make sure that personal information is encrypted. Encryption is one of the ways in which you can avoid having to report a data breach on account of encryption is a way you can demonstrate that there is no likelihood of a risk arising to the data subjects, and therefore you can choose on that basis not to report a data breach. Encryption should be a very standard and normal part of what any organization does, both of data at rest in databases and data at flight in email. Keep up to date, train your staff. Think about the number of breaches which arise because of successful social engineering or similar types of attacks. Train staff, keep them up to date, and make sure that they're going to be aware of and resist the type of attacks which are focused on them. Those are good first things to be doing because, hey, you should be doing them anyway. Protecting the organization against cybersecurity breaches is a good thing to be doing. So stretch out, reinforce, really support the cyber security people inside the organization, help them expand and improve the quality of what they're doing. At the same time as that, you can start focusing on what personal data you're processing, where is it? And that's really about doing a data inventory and a data flow audit. A data inventory is about identifying what the chunks of personal data are that you've got. Where have you collected personal data? Where did it come from? The data flow looks at how data is collected, where it's stored, who has access to it, who else gets to see it, where it gets sent to. And that enables you then to think about the entrance and exit points from your network, where data comes in and where it leaves, what security is like in each of those areas, where it's transiting through to other organizations with whom you might need to have a data processing agreement. And it also enables you to see not just where it's originated, but also where data is altered, updated, and destroyed. All of those are different forms of processing, and you need to have effectively under control from a GDPR point of view. So data inventory and data flow audit, it's quite a time-consuming exercise. In a public authority, it's likely to be a very time-consuming exercise indeed, because you've got big chunks of data, and unless you've already got an effective data flow audit, the reality is that tracking exactly where all of the elements of data come from, who's using it, is going to be quite time-consuming. And therefore, the faster you get started on it, the better. So you're going to get visibility of your data flows. You're going to be able to generate better protection strategies because you can see where data is changed and stored. You can make sure that you're complying with the legal requirements you've got around the data. You can make sure the controls you've got in place are not only appropriate, but also effective and efficient. You can manage data better through its life cycle. Data should be deleted or removed when it's no longer required for the original purposes for which it was collected. Doing that can, of course, drive down costs over the long time. It reduces exposure, better classifications of data, keeping it up to date more often, again, reduces the likelihood of upset data subjects, reduces the likelihood of breaches. You're able to, out of an effective data flow audit, identify what work you need to do with partners and providers, and of course it enables you to work out how to respond to a data breach. You can't really, you think about what you have to report, unless you know where data came from. You may even struggle to know what data the attackers have got access to, and the data flow audit is a very key part of enabling you to respond to a breach. So a data mapping exercise starts with identifying personal data, and that means identifying personal data that you collect, all the different purposes for which you collect it, and you may well collect data by means of a contract with a third party. You may well have outsourced activities that collect personal data for you, and all of those you need to identify. You need to find all of the places in which personal data is collected for any of the functions for which as a public authority you're responsible, and make sure that you've tracked where it's coming from and where it's coming into. Once you know what you've got, where it's flowing, where it's going to, you can then think about whether you've got the appropriate technical and organizational safeguards in place. GDPR doesn't define any of those words, not appropriate, not technical or organizational. So you have to work that out, usually on the basis of a risk assessment, usually on the basis of a proper balance between reducing risk to data subjects and the cost to the public authority of putting those controls in place. But there needs to be a structured, documented, auditable method of arriving at those decisions, and having arrived at those decisions, of deploying the measures, the safeguards that you've selected. You also need to make sure that you've understood your legal and regulatory obligations in relation to that data processing. And the legal and regulatory obligations are not merely those that are set out in the 6 data protection principles. Those, of course, are important, but you're going to have legal obligations in terms of retaining data for statutory reporting purposes, or in relation to any one of a number of other statutes or regulations. And there will be a number of circumstances under which there could be conflicts, and you have to determine which of those requirements has precedence, because that's what will set for you the basis on which you process and, above all, retain the data. So if you look at the data flow, then what you're looking at is the key elements: name, email, address. You're looking at all of those data items: health, criminal records, biometrics. You're looking at the formats in which data is collected: hard copy or digital format. Is it on a database? You're looking at how it's moved, the transfer methods. Is it moved by email, by post, by telephone? Remember that voice data is personal data. Social media, and you're looking at where it might be stored: in the authorities' premises, in the cloud, at third parties. All of those are elements of mapping data across the organization. And a data flow map might look something like what you see on the screen here. This is a data flow map which looks at the flow of data into a small sales organization and tracks the different types of data and the different ways in which it's used, the different steps that take place, the different items by which data is viewed. And it enables you, therefore, to start thinking about not just who sees the data, but whether the environment within which it's dealt is appropriate and is secure in terms of the purposes for which the data was collected. A data flow map really is the first step in embedding data protection by design and by default in the organization. The second step is a data protection impact assessment, and the third step, of course, is doing it. But you can't even do a data protection impact assessment unless you know what the data flow is. You have to be able to track every one of those steps. So data protection by design, a key requirement of GDPR, if you like, part of the accountability that GDPR expects to see demonstrated, comes through a data flow map. So you then need to think about processes and policies. A key part of dealing with data subjects and in particular in dealing with data subject access requests. So your documented processes, the data protection policy, your records and controls policy, all of those kinds of documents which are contained, there is an IT governance documentation toolkit you can access, which has got all of those templated documents in it. One of the key sets of documents is the data subject access request procedures, which you can see identified on the screen there. And it's critical because one of the things that's happened in GDPR is that the opportunity to charge a data subject £10 for accessing their data is removed. It's possible, I guess, that the member states might bring that in, but it's difficult to see how that would stand up given that GDPR is supposed to provide a level playing field across the European Union, and that's likely to mean that the number of people requesting their data will go up very considerably. There's no requirement in GDPR for that request to be written, so it can be a verbal request. Your processes need to enable you to identify you've got a data subject access request and enable you to respond to it, and there's now only 1 month within which to respond. So getting your documentation and training people in how to deal with your operation is pretty critical. And data subject access requests are driven by the fact that data subjects have rights. Of course, they always did have rights, but those rights are now much more clearly set out, and there are a couple of new ones. They're also captured in the idea that controllers have to facilitate the exercise of data subject rights. And so those rights are the right to be informed, to get a privacy notice from you before you start processing data. This doesn't always apply to some public authority activity. The right of access to know what you are actually doing, to find out if you're doing what you told them you were doing, the right to fix things that are wrong, to have data erased that's no longer relevant. That's in particular, it's not an absolute right, but it is certainly triggered by consent. And so in many issues, you will want to make sure that consent is not the lawful basis on which you're processing data, not least because from a practical point of view, public authorities are not in an equal position in relation to the fair giving of consent. So the right to erasure, the right to restrict processing, the right to get data back is another new right. The right to object to processing, where that's based on legitimate interests or similar. And of course, the right to be informed in advance about the use of their data for automated decision-making and profiling. Controller must facilitate, must act on the request of the data subject to give them this information. The only reason you can use to not do that is that it's actually not possible for you to identify the data subject. As I said, the data subject access request is really just a request under DPA. It used to be written, and GDPR doesn't have to be written, about information to which they're entitled. You've got 1 month to respond. The reality is that at that point, a data subject could be asking for all the data you're holding about them, including what's archived or held in backups. They're entitled to know all of that, and you've got to redact and not give them information that's about other people, because your obligation to protect the rights of everybody remains. Of course, there are circumstances under which you can extend the 1 month by a second month, where the amount of work you have to do is onerous, and you could potentially generate a charge to the data subject, but the onus is on you to prove that the work that you're doing is unreasonably substantial. So very significant changes, very big challenges, and you've got between now and the 25th of May to be ready for them. We kind of expect that the 26th of May will see the start of a rapidly increasing number of data subject access requests from people who want to find out how their new rights work. Simon.
Thank you, Alan. Let's get back control. There we go. So in this section, we're going to drill down a little bit more on some of the main components of the compliant activities and look at some of the practicalities that Alan's been talking about, and particular the roles as well, of which the most prominent one is, I would say for this, the data protection officer. Now, most authorities will have a formal DPO in place, or at least have delegated the responsibilities of that role to an officer within the council. GDPR is going to raise the profile of this role, and as a result, it's going to increase, I think, the scarcity of accomplished DPOs. At its heart, the role is the driving force behind your organisation's data protection strategy. The DPO is the arbiter of the data protection laws as they apply to your organisation and its business operations, and in that sense, they act as the advisor and the monitor, and are the key link between your data subjects, the organisation, and the supervisory authority. So not all organisations need a DPO and a GDPR, but if you're a public authority, there's some exceptions there, but or if you meet two of the other conditions that are required, then you will require a DPO. Because of the DPO's position and how it's set out in the GDPR, the individual taking the role's got to have competencies to influence and challenge all the way up to the CEO. So I think it's fair to say they're going to need some size 9 shoes, if not bigger. They've got to have effective and independent oversight across the whole organisation. So their advice should be observed, even if it's not accepted by the organisation. The organisation still has that right. But it's important that the DPO has that freedom to express their opinions and views. They've also got to have a secure means of communication with employees, so that employees can effectively engage confidentially with the DPO without hindrance, which does kind of suggest that they need to be sufficiently available and on site. And they've also got to be able to interact with IT and be able to engage with and interpret what IT are telling them, which I think is in no mean feat. Certainly some of the IT people I've been talking to, sometimes to me it feels like a different language. But they've got to set out how the organisation is going to meet the criteria of data protection by design and default, and make sure that data protection impact assessments are carried out appropriately and for the right reasons. You don't need to carry out a DPIA for everything, but the DPO will be able to give guidance on where you need to do that. So I think if you haven't got it by now, good DPOs are going to be quite special and relatively rare. Finding and keeping a DPO in local authority is going to be difficult, and it's certainly going to get tougher as we get near the compliance deadline of May 2018. Many of you might be familiar, there's a working party, they call the Article 29 Working Party. They produced some final guidelines on the DPO role early this year. It's just in April. So they've said that there can only be one DPO for an organisation. The intention of that is to prevent what they've called the virtualisation of the role, but this role can act across a number of organisations with appropriate support, and that's taking into account the size of those organisations, and also so long as the DPO is in that position to communicate effectively with data subjects and employees and cooperate with the supervisory authority. So what they're trying to say is don't put a poor soul in place of covering 3 or 4 very large organisations, because they're just not going to be able to do the job properly. In addition, the Working Party confirmed that an external DPO can be appointed on the basis of a service contract. Now, if that's used, what they've said is there must be a designated lead person that needs to be appointed, but they can be supported by a team. So this gives some flexibility, I think, to councils. Of course, even if you outsource it effectively here, that organisation has still got to fulfil all the responsibilities and requirements of that DPO role as if they were an officer within the organisation, and absolutely no conflict of interest. Okay, so we're going to talk now about the data audit. We've talked about why it's important and what you need to do, but in this section, what we want to explore is more about the high. So I'd like to bring in my colleague Robert Florendine here into this conversation. Hi, Robert. So Robert, I was wondering if you could help answer, what does an authority need to consider when designing and constructing their data audit?
Yes, thank you very much. Yeah, well, I think the infographic on screen really hits at the heart of some of the business and technical challenges associated with it. If you consider that the very pervasive and nature of personal data and how it can travel throughout an entire organization's network, it can end up in so many different types of systems. Obviously, you kind of got your first kind of category of systems which are designed by their very nature to hold personal data. So your kind of your customer management systems, your HR systems, things like that. But then in conducting your data audit, you have to be incredibly careful around your analysis of some of the unstructured file stores, those that contain a mixture of different types of documents, predominantly unstructured, that may actually contain quite important and sensitive documents just lurking within them. So your classic examples would be your file stores, your backup systems, your document management systems, your intranets. And also, if you could kind of consider the dangers of dark data as well. So that's kind of the non-text searchable type of data, like maybe if you take passport scans from kind of customers or people that you deal with, then if they're not kind of scanned in the appropriate way using OCR technology, then you need to kind of bring those to life. Both from a kind of data auditing perspective to understand that you've got it, but then also from a DSAR perspective as well, because if a person was to ask for their passport scan, their passport copy or driving license, whatever the case might be, and it's kind of held in dark data or not text searchable, then that's going to not come up on your searches. So this is the kind of landscape that we're dealing with. And also bear in mind the likelihood that personal data has been uploaded into your kind of cloud services, and quite often kind of possibly just done in a way by a user that the business isn't aware of, kind of what we call shadow IT. If you can kind of go to the next slide for me. Yeah, so that's kind of indicating the difference between the two types of systems. Thank you. All right, so if you're conducting a data audit, especially on these kind of unstructured file systems like your file servers, your document management systems, etc., then PII can just exist within these unstructured documents. And say you're just kind of doing this as a manual process, it's been assigned to somebody, then they would, just in picking up one document, they would be able to identify things like names, addresses, and then the whole broad definition of personal data. So just doing that on an individual basis can be incredibly time-consuming, as kind of Alan was alluding to. So there is technology out there that can convert that unstructured data into structured data to enable you to understand. And imagine we were now doing this on a huge scale with the exponential growth in enterprise data. You could have file servers that contain hundreds of thousands, even millions of different documents, and all of these things could contain personal data within them. So if you can go to the next slide for me again. Yeah, so if we're kind of dealing with that very, very large amount of data, you need to be able to convert it into a structured form. And then with that, once it's in a structured form, you can then start to make decisions around it, like the detection of, say, sensitive personal data, and then being able to make an assessment on whether or not it poses a risk in the form in which it's stored. If you go to the next slide for me again. So in terms of both a work process and a kind of technical workflow, for conducting a data audit of these types of systems like your file servers, DMSs, intranets, extranets, etc. There are solutions out there that kind of offer you that what we call a connectivity layer that can actually kind of connect and unify all these different types of systems, and it can crawl these different types of systems and also have an OCR engine built into it to be able to bring to life all of those types of dark data that I was mentioning, like passport scans and driving licenses, etc. And also, if once you've kind of crawled that data, the technology can also enable you to run detectors against those, quite often using quite sophisticated techniques in order to identify if a name, an address, a date of birth, or even some of the more sensitive categories of personal data, like dictionaries that look up kind of common religious themes or trade union membership, etc. So it trying to kind of cover the whole spectrum of personal data. Similarly, kind of with that data, you can also do document classification exercises, kind of feeding a system examples of, say, 50 passport scans, and then using that training, machines can then automate the process of identifying the rest. And kind of once you've crawled that data, once you've detected both the minutiae of PII within the unstructured documents, or even done a document classification exercise, you're then getting much more close to the process of being able to identify your biggest risks. And there are systems that can even do a classification exercise for you as well, to say, this could be an Article 9 category of sensitive data. And depending on the metadata that it's crawled it from, you can then start to put all that into a report, which will then highlight fairly autonomously the types of personal information that you have, and then whether it's kind of looking at the create date or last edit date. If it's been held on for too long, it's become redundant, or if it's a sensitive type of personal data and the permissions on that particular item are very open, or if it's not encrypted. All of these kind of major flags can then drive your remedial decisions, or they may even be kind of manual processes to kind of allocate X amount of documents to a particular person to then do a cleanup exercise on, such as removing, redacting, tightening security, etc. If you can go on to the next slide for me, Simon. Thank you. Also, as part of a data audit, organizations are also having to look at a lot of their supplier agreements. And also maybe even doing a review of employment contracts too, to look at the wording of the data protection provisions within them, and then perhaps using in-house counsel or external legal advisors to advise on whether or not those provisions are compliant with GDPR. So the types of data points that you're looking for within these agreements could be what is the protocol in the event of a breach? Is that data being transferred out of a particular jurisdiction? And there's a large number of different ones as well. I think in employment contracts can no longer rely on provisions around the employee giving consent to the employer for processing of sensitive data, because GDPR considers there's an imbalance with the employee-employer relationship, where so those types of consent provisions may not be an appropriate lawful basis of processing. Obviously, there are others that the employer would rely upon, but it's just kind of showing you that even within something that sounds like an employment contract, those types of provisions might not be enforceable anymore. So this is kind of, and especially if you consider as an organization, you may have entered into so many different types of contracts with different parties, that this can be a labor-intensive process of having to look through lots of different contracts. And there are contract review tools out there that can do this job for you automatically, kind of using things like machine learning to train it to find particular types of provisions and then be able to surface those straight away just by uploading the contract into the system. Right, if you could go to the next slide for me. Yeah, so this kind of gives you a workflow. So you would again using similar types of technology, using a connectivity layer to connect into where those types of contracts or agreements might be housed, or you can just kind of upload it into a system, creating a new project. So it might be the review of employment contracts, the review of supplier agreements, going through a classification exercise to kind of identify what type of agreements they are and give them a particular flag. And then, as I was saying, train the system in order to find particular types of provisions. And then the more you train the system, it can actually do a lot of that work independently to be able to find the relevant provisions that you need to review as part of your data auditing exercise. And ultimately that report can then just be handed over to a legal professional or just be dealt with in-house. But it's technologies like this have certainly been shown to increase the time, reduce the time these processes take by up to kind of 60 to 80%. So it's a real time saver, especially if we're considering that the GDPR is coming into force in less than 9 months. If you can go on to the next slide for me. So
it's interesting. Yes, and I was just going to say that I always thought that the name data audit's a bit of a misnomer. I always think it's a bit aligned to the accounting audit, which is just a once a year type major activity. Where of course for this, it's an activity that organisations need to do continuously because that personal data, contract data is changing all the time. So I think it really does enforce the need for organisations to look at where technology could help them do the heavy lifting, but also to provide that sustainability in terms of their view of personal data and what they're caretaking in their organisation at a particular time. So I think we're just going to move on to the subject access request. So let's perfect. Well, we've done the audit, we've got the technology in place. The next bit is to do that subject access request. So I think just run a couple of points here. I think that hopefully resonate with the authorities that are listening. That the authorities today have to do subject access requests today anyway, along with freedom of information requests, of course. And I'm finding PII is predominantly, probably typically, a manual process where a request for information comes in, possibly to a central team, and then gets sent out to the relevant departments for them to go and do their searching in their own data sets and stores. It's going to be reasonable to expect that the volume of requests such as these are going to increase in May next year, vexatious or otherwise. You can imagine those in your authorities. I think you know the individuals that will be calling you up on the first day saying, can you tell me what you hold? Not least, this is going to get stirred up by the media. There'll be a lot of media attention on GDPR, I'm sure. And the GDPR itself is going to broaden the terms of PII. It certainly evolves the current Data Protection Act requirements. So there is some learning and understanding to be done here, whether it's in your customer services and your agents that take these requests or in the teams that manage them. In addition, as we mentioned, subject access requests do not extend to the whole document. So that redaction and those extraction activities, again, which you would undoubtedly be doing today, they stay. That's got to stay in place. And you've obviously got less time to do all this. I mentioned before, we've only got 30 days, and particularly in this world of what I think is instant gratification, slow responses, I think are going to be less tolerated by citizens and the digerati, if we like. And people are so used now to using their phones and having access to information. And don't forget, you've got to validate the individual's identity at the front of the process as well before you process. And again, in the digital age, with services such as government's Verify scheme, citizens are increasingly going to be expecting authorities to automate as much of this as possible. So, Bob, if we look across the process, where where would you say is it that authorities could automate the process, and what might they need to consider?
Oh, for DSARs, I think consideration should be both, not just in terms of the customers that you're serving, but then also consider they're a very big reality in terms of employees and past employees too. I think that's something that's occasionally overlooked. The employees just have just as much right to make DSARs, and also if you consider customer data is usually compartmentalized a little bit more, but with employees, the data footprint that they leave behind could be much greater. And also DSARs in the current regime are kind of being used for sometimes malicious or strategic reasons, especially if you kind of have a disgruntled employee who's then looking for that particular organization to maybe reveal a little bit too much under a DSAR, which then can lead to an employment tribunal, and that information be used against them. So, kind of consider that they could come from different angles and for different reasons. But ultimately, the technical challenges are the same. If you remember back to that infographic around where personal data is going to be, you're going to need, again, a connectivity layer to be able to connect into all those systems. On the receipt of a DSAR, it could come from different, obviously come from different people in different forms and also different requests. And I think having a kind of management tool to say when DSARs were received, so being able to kind of create a new job, search job essentially, saying when it was received, your kind of 30-day countdown, who's the personal details of the person who sent it, and then even kind of adding in some additional metadata as well, like the evidence for that particular request. So, because being able to look back on previous jobs is really useful, because if someone's maybe submitting too many, kind of being a nuisance, then I think that might be one of the exemptions or kickbacks that you can use to maybe charge someone for further jobs that they've been further DSARs that they've been submitting. So once you kind of again connect into that system and be able to crawl that data, you're essentially searching on that person's name and then permutations of that name, as well as other criteria that's related to that person, maybe a customer number or whatever the case might be. So you kind of need that advanced search rules within an application to be able to cover all of those different permutations of someone's identity. And as we said, there's no reason why this couldn't be automated according to certain rules. But once you kind of get down to the review process is going to, again, really involve a condensation, kind of a condensing exercise. Imagine there's, especially on structured data, there could be a 1,000-page document that only contains one paragraph of someone's personal data. To expedite that process and make it a lot less labor intensive, you really only want to see that that one paragraph and maybe the paragraph before and after to kind of check what elements of PII exist, especially within unstructured data. And you're going to be doing a fairly intensive redaction exercise of the content, as well as an extraction exercise of pulling that personal data out. So some of these tasks could be automated, but then going back to my earlier point about how sometimes DSARs can be made for strategic or malicious purposes to extract information, especially by kind of past employees, then you want to have a kind of human review process in here as well, rather than relying entirely on an automated system to do that. So so once that kind of data has been kind of put into an appropriate form, transition of that personal data is something to really consider as well, because suggestions are that you shouldn't just be emailing it to someone, because that's not a secure way of sending that person's personal data back to them. You kind of need to be looking at appropriate portals in which to save that in a secure way so that it can just be retrieved. So that's again something to consider too. And once you've actually provided that, then it's very likely that you might get a request to for a further enforcement of someone's rights. Say, please delete everything you have on me, or please port that from one provider to another. And again, those can kind of produce quite big logistical challenges as well. If we talk about in unstructured data terms, then deletion from or redaction from PDFs or might not be too much of a challenge, but your kind of applications like Microsoft Word don't kind of lend themselves as well to redaction or deletion. And then you also have to consider that there may be documents that someone's personal information is in that you're under a legal obligation to keep the whole document for a longer period of time, such as board minutes or things related to kind of obligations to keep data a part of money laundering rules and things. So technology can kind of certainly help within certain phases and segments, but there'll still be quite a few challenges along the way, and that's kind of where the definition of that business process is really important to nail.
Great. Thanks very much for that. So we're just about coming up to time here. So we've covered some of the challenges, opportunities and solutions open to organisations in complying with the regulation. And as I said at the start, it is about doing the right thing by customers and citizens. There are lots of places to get help. The ICO site is incredibly helpful. I've got a lot of information on there about GDPR and also Data Protection Act as well. And with IT governance and Agilisys, you've also got access to some various tools, guides, training, which also can be booked online, and also consultancy and technical services as well as required. So these are all in the webinar. I won't go through them, but we can the webinar, the slides will be available after. I'm not sure if we've got time for questions. I'll just ask Alan.
I think technically we're out of time, Simon. You're right, but we should be able to get the questions all answered offline and shared with delegates. So if we send the slides out in the course of the next couple of business days, the answers we should be able to get pulled together between us and the team, and take maybe a week or 10 days after that and send the questions and answers out to everybody who's on the webinar.
Great. Okay, thank you. Thanks everyone for attending. Good luck with the GDPR program.
Thanks everybody. Have a good weekend.